Thank you. There's really only one point that I would wish to make, and it's a point that I regret that I didn't make in my contribution to the book. And it has, I think, both practical and theoretical implications. The High Court can handle approximately 60 or 70 cases a year, and I can assure you that that's quite a burden. The selection of those 60 or 70 cases is made from some about 700 to 800 applications that are made each year. I don't think it's practical for the court to handle any more cases. Now, if a Bill of Rights is introduced, whether it comes in as legislation, assuming a legislative competence on the part of the Commonwealth to do that, or whether it comes in as a result of a referendum in an entrenched form, the fact is that a number of cases on it will come to the High Court. Indeed, some judges will find it very attractive to deal with rights questions rather than other questions. Rights questions are seductive. They involve major public political issues, and I don't think there's any question that some judges would prefer to handle those to handling the more rigorous work involved in what most people would call black letter law. That is to say that, as a practical matter, rights cases would tend to crowd out all of the other, I think, very important black letter law cases that would otherwise come to the High Court. And I think this is a serious practical consideration. What it would mean is that the High Court would cease, I think, to hear and to settle much of the law of Australia, which it now does. As a practical matter, it just wouldn't be able to handle it. Take one of my former colleagues, for example, Michael Kirby. Michael makes no secret at all of his appetite for questions of this kind, and he wouldn't be alone in that regard. Judge after judge, if there is a Bill of Rights, will want to deal with these questions and hear them, and in the result, I think that the learning and intellectual probity and intellectual standing of the High Court will suffer. That's simply a practical view, but I think it is a serious one, and it's a point, I think it involves a point that I wish I'd made in my contribution. The only other thing I would say is this, and I'll retail an anecdote that was told to me by another retired judge. He said that he was talking to an American judge, and he asked him how he found the work. And he said, look, he said, I'm in fact the judge for leaking school roofs. And he said, well, what do you mean by that? He said, well, the rights legislation in this state, and of course the states have rights legislation as well as the federal Bill of Rights, which is entrenched in the federal constitution. He said, all students have got a right to education. And he said, in consequence, that has meant that there are repeated applications to the court to make orders compelling the Education Authority to provide all of the necessary infrastructure for schools, and that includes leaking roofs. And he said, that's about all the work I do. Now that is the sort of consequence that you can get from a Bill of Rights, and I don't think people have thought this through. Thank you for the opportunity of allowing me to add that one point.